The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention. The court is now sitting. God save the United States and this honorable court.
Please be seated. Good morning, everybody. Welcome to the Fourth Circuit. We have two cases, actually three, I guess, and two have been consolidated this morning. So, Mr. Skaggs, whenever you're ready, sir.
Yes, Judge. You want to address your issue? Or?
Yes, Your Honor. May it please the court, Paul Cronus on behalf of the appellees. By joint agreement, we have just a very brief housekeeping matter, if I could address that.
Certainly.
Thank you. The appellants put together errata sheets. There were two of them, and they had 6 different errata. We wanted to advise the court that we do not object to any of them.
Okay.
Secondly, on behalf of the appellees, and very briefly, in the NITI brief at page 20, the NITI response brief, appellee's response brief at page 20 and at page 27, the appellees correctly cited, provided the correct citation. They also referenced the judge correctly. They referred to the case, the court the case came from incorrectly. Counsel agrees that that should be changed as well, counsel of the appellants. In the Leeson response brief at page 19, there is a reference to the LIP decision, LIPP, and the citation should be 2017 WL 253162. Thank you.
And you'll never hear me object to something like that.
Yes, sir.
No
Thank
objection.
you. Thank you, Mr. Cronus, for bringing that to our attention.
Thank you.
All right, Mr. Skaggs.
Yes, if it pleases the court, I'm John Skaggs from Charleston, West Virginia. I represent the appellants in these consolidated cases, plaintiffs below. And
Mr. Skaggs, it's entirely up to you, but if you want to remove your mask, you can. I'll leave it up to you.
well, I want to set a good example.
We understand. Go ahead.
I had it. It changes your perspective.
And I don't mean to pressure you in any way, sir. If
No,
you want to leave it
not-
on, that's fine. I just didn't know whether you understood that you could.
No.
Yeah.
So I've been trying to figure out an efficient way to address the core of the situation. We tried to brief it as thoroughly as we could with the various duty of care cases. And you've got this situation, of course, where you have a tort type duty of care under that Akins case. And we have also a claim, particularly with Ellswick, based on the assumption of the lease and rents. But to me, I think what I want to get across starts with the infamous email that was sent to Mrs. Booker at Wells Fargo, because I think that will establish several different points for each of those types of theories. And what she said is, what he said was this, Dario, "Dear Mrs. Booker, hope you were well. Please find the attached enclosed disbursement request for Terra Retail Group loan, which has been submitted to CMS Reserves on January 21st, 2016. And he says, we have 2 critical repairs we would like to ask for you to please expedite release." And first, right off the bat, he uses the term critical repairs. And so if you look at it from the standpoint of we're
Can I ask you a question about that? So,
Yes, sir.
The party that you're referencing is asking for a disbursement request from the bank, but doesn't the agreement require that the repairs be made up front and then reimbursement be sought later?
Well, I saw that in the decision that was filed by the defendants on April 27th, because that's in Judge Bailey's decision. I don't know, because we didn't have discovery in this case. This was back on a motion to dismiss, of course. The way I read...
Are you saying that's not in this record? The agreement?
I don't think the entirety of the document that governs that is in the record. I do have a copy of it. The way I read it is I did not read that as being something they had to do in advance. My understanding was that and I'm looking at page 82 of the document that was filed below. Let's see. Borrower shall submit a request for payment to lender at least 30 days prior to the date on which borrower requests such payment to be made and specifies the required repairs to be paid. So as I read that, it's a situation where, and I think it's fair to say that this is what he was contemplating. It's a situation where they can go to the Wells Fargo and say, you're holding this accumulation of funds and we have a critical urgent need, and will you pay us?
Okay, and I don't want you to get bogged down in these details, but I guess maybe the broader question is, I mean, this lender agreement is typical of most agreements that I've seen, that essentially absolves the lender of any responsibility to do much of anything. So what makes this case different? Why don't we just simply enforce the agreement that the parties entered into?
Because I think in looking at the law that governs here and the foreseeability issues, in this unique situation, and I'm not out to undermine secured mortgage bonds, but in this unique situation, Wells Fargo took into a hard lockbox the entirety of the rents that were paid by the tenants. And in fact, I did not realize this until I was reviewing Judge Bailey's decision that was filed last week. But apparently, I'm looking at page 12. Let's see if that's it. They had multiple loans like this. So again, you've got a situation where Wells Fargo has 3 of these types of loans with this one party. And so you've got the situation, I think, under Akins versus DeBow, the economic loss case, and under conventional foreseeability and duty of care law for Wells Fargo, because they're taking all the money.
Can I ask you about that?
Yes.
Are you arguing that a test other than the economic loss test applies for your negligence claim?
Yes.
So you're saying the court below erred in applying the economic loss rule, or just that they applied it incorrectly?
Well, I think it's multiple situations, if I may answer that way. As to the tenant, I think that's clearly an economic loss rule. All right. And then I also argue that there's a general duty of care at all times to comport yourself as a reasonable person. And that, of course, would be applicable, I think, across the board, because our point is that Wells Fargo had the money, had the authority, had the powers of attorney to act to prevent this ridiculous situation from happening. And if you look at the way they talk about foreseeability and duty of care, you look at the consequences of acting, what the burden will be on the defendant, what happens if they're required to do something, what happens if they aren't. The burden of guarding against this event was $24,000 against a multi-million-dollar loan on this property at a time when they had $227,000 in the lockbox.
I ask you this a different way. What is your best, I understand you have broad statements of law that you assert apply here, but have you identified any case where an assignment was construed to delegate duties, even though the assignment says in about as clear language as you possibly can, this assignment does not delegate any duties at all? So what is a case that actually imposes liability when there's an agreement that says that?
Well, I think that Lip case does. And again, I think, to me, the answer to your question goes to the multiple statements by the lower courts is we're going to open the floodgates. There are going to be hundreds of cases. There's going to be this awful situation with people abusing these. This is a very unique set of circumstances. You have a uniquely sited shopping center, one-way in or out. These very sophisticated financial institutions loan money on. You've got the issue of the hard lockbox, which I think is important. This is not a case where the landlord pays his interest, principal, and whatever the agreed to escrow amounts might be. They took all the money. And our argument, of course, on the assumption of leases and rents, which was filed it's a public document, it's a lease, it's put in the court record, the property record. The point of it is, it says full, complete, and not for security purposes only. So,
I don't want to take us too far afield, but I do want to give you a chance to respond to something that bothers me.
okay.
I'm not at all convinced that there is an adequate pleading of subject matter jurisdiction in NITI. I don't see where in the complaint it alleges there is complete diversity between the parties. This only affects NITI. It doesn't affect the other case. But could you, I guess, attempt to address for me why I shouldn't conclude that there are inadequate allegations of subject matter jurisdiction?
I'll try. I didn't anticipate that. She's a resident of the state of West Virginia.
Is that in the, so I'm looking, maybe I'll try helping. I'm looking at the complaint.
I might have inartfully pleaded her residency.
So paragraph 1 says she's employed by Kmart, a shopping center in West Virginia. That doesn't allege that she is a resident of West Virginia.
No, you're quite right. That was inartfully pled if that's the case. I can represent to you that she is in fact.
And then paragraph 4, I guess, says COM 2013 CCR 12 LLC is a New York common law trust. Its address is in Cincinnati, Ohio. But I'm not sure that we've alleged the jurisdiction of all the defendants either.
I'm not going to argue with you. I don't know how else to answer that. It is inartfully pleaded. If it isn't clear from the complaint that she's a resident of West Virginia, then that's inartful pleading on my part, and I apologize. I don't know how else to answer your question, Judge.
Understood. I did want to give you a chance to answer it, so please go ahead.
So to me, we come back to the ALR, and as I argue, I think the language regarding the this doesn't apply to us. Well, number one, the contract itself is inherently contradictory. What does it mean? If it says at the beginning a full, complete assignment of leases, not rent proceeds, leases and rents, and not for security purposes only. And then later on, buried in the bottom, it has these exclusionary language. To me, you just have to look at the entirety of the document and the transaction. And I think the conclusion is that in this unique circumstance, Wells Fargo, by reason of its conduct and the course of dealing between it and, whatever they called themselves, Terra, the property management company.
What do you mean by course of dealing? Because is there any evidence in the record that they undertook repairs before?
Well, that's, again, we're back to Judge Bailey's decision, because he indicates in there as part of their facts that there was back and forth between these two companies and that there had been some form of intercourse in the past where they did have repairs and they did follow this, we paid for it, he alleges. The problem is this was a motion to dismiss on our part, and I can't really say because we haven't had the discovery on that particular issue. And that's one of the things that's hanging out there that could make a difference in these cases, because on these where you characterize it as a special relationship or a limited, look, I'm down to 35 seconds. Whether it's a special relationship or however you look at it, those special circumstances could well turn on the course of dealing in the class between the parties. So I'm down to 22 seconds, and I will, unless you've got other questions, I will sit down.
Thank you, Mr. Skaggs. You've got some time left for rebuttal. Mr. Cronus?
May it please the court, Paul Cronus on behalf of the appellees. I think where I will start is to briefly address some of the points that we just heard. The court asked appellant's counsel, why is this case different? What is different about it that justifies the relief that they're seeking, which is that these claims should be sustained? And the answer is that this case is not different. It is not different from the law that is already well established. The facts do not create a difference at all. What would be different is if the court were to allow these types of claims, as attenuated as they are, to be a basis for recovery, in which case it would not only be in derogation of the law, but it would also create a practical reality that the law is not designed to support. And what I mean by that specifically is, what would the commercial lending market be if they could never underwrite the liability for making a loan with respect to, for example, a commercial shopping center like this one?
Mr. Cronus, can I ask you what I think is the hardest thing in this case for you, and that involves the tenant. So assume, for the sake of argument, that I'm persuaded by the arguments about employees and about neighbors, and those seem covered by a traditional pure economic loss rule. But this tenant thing is very strange. And I guess when you open by saying what makes this case different, I mean, what makes this case different is that your client took all of the rent money and then asserted the ability to veto capital expenditures, or at least veto reimbursement for capital expenditures to maintain the very property being secured. That strikes me as unusual, and it strikes me as potentially a difference between the typical case. I mean, I've not been doing this for a long time, but it seems to me strange that you insist on taking all of the rent money and then saying you have to sign off on repairs, and then argue that there is no duty whatsoever, even if you unjustifiably refuse the right to make repairs. Would you like to address that?
I would, Your Honor. Thank you. First and foremost, the loan agreement bargained for, which was executed by the parties, says what it says, and it sets up the very specifics of, I believe, everything that Your Honor has raised. It blesses them, it condones them. They got millions of dollars, and they chose to and did enter into certain.
Well, wait, no. Terra got millions of dollars. The people whose businesses were interrupted and disrupted did not get millions of dollars. Terra got millions of dollars. I mean, I know the problem in this case is that Terra is bankrupt, that in any sensible world, they would sue Terra, not you, but Terra's bankrupt. So that's the sort of background of all of this. But
Sure.
But the tenants didn't get millions of dollars. So it makes total sense why Terra would agree to this, but I think there is some force to the argument of, well, the tenants didn't bargain for this.
You're right. I was referring to Terra, Your Honor. It was not referring to the tenants themselves. No, the tenants did not, but the tenants aren't a party to any agreement with the appellees in this case. They are not, as a matter of law, the sole beneficiary, which, they could try to make a claim for that. They have, and it is not supported by the law. In other words, they simply, while I understand the peculiarity that the court is referencing, it's simply not supported by the law then that they can make a jump and say, yes, I'm a tenant. And by being a tenant alone, without any contractual relationship, without any special relationship, without any fiduciary relationship, that alone is sufficient for me to be able to bring and support this claim.
Well, okay. Can I a follow-up question on that then? So you said there is no contract. I totally agree. But I mean, the whole notion of special relationship is that sometimes there are people who don't have a contract, who can nonetheless sue on the obligation. So could you, if you're saying they don't have, you just said they don't have a special relationship, could you give me an example of what would create a special relationship with Wells Fargo? Like, what is the factual scenario where someone who is not a party to the loan agreement would have a special relationship?
Sure, I can think of a possibility, and a possible special relationship would be that which the lessee has with the owner of the building, with the landlord themselves. There is that relationship. Here we don't have that.
But hold on, the lessee has a contract with the owner of the building. They don't need the special relationship test. Those folks have a contract.
That's true, Your
The
Honor.
special relationship test is about imposing liability sometimes in situations where the people don't have a contract. So I don't think you can give me an example where people have a contract. What is an example where there is not a contract between Wells Fargo and someone, but Wells Fargo would have a special relationship?
Well, if, for example, we were talking about a fiduciary relationship, right, as being a form of special relationship, the law on that is clear. And the law says that the party seeking to prove that relationship has to repose confidence into the party who is purported to have the fiduciary obligation. And in exchange, that party who has the fiduciary obligation has to acknowledge that they are aware of that reposing of confidence. That is not the facts here under any stretch. And it's not just because, Your Honor, there's no contractual relationship, is because there is no demonstration of that confidence in either of direction that could possibly cause them to repose confidence.
So I assume that Terra could sue your client for unjustifiably withholding these funds, right?
I wouldn't agree with that, Your Honor.
Wait, so then is your question that your client has, I guess that's the question. The question says that Terra had to ask your client if they would disperse funds for repairs. And is your view that the contract gives your client the exclusive, despotic, arbitrary authority to deny reimbursement whenever it feels like it, for whatever reason it feels like it?
Well, if we're talking about the
Terra and your client clearly have a contract. So I'm trying to think about if Terra could have sued your client for breach of contract.
right. So if we're talking about the Terra and appellee relationship, I mean, first we've got all the issues that they haven't responded to with respect to Wells Fargo not being a party to most of the contracts, only one. And secondly, Your Honor, with respect to that specific relationship, the district court has already ruled in the case between Terra and the appellees. The district court has already ruled that there was no relationship, and as a matter of law, throughout very similar, if not just the same types of claims that are before this court with respect to significantly more attenuated claimants than Terra itself. So my response to Your Honor would be, can they sue? No. My answer would be, they did sue, they lost, and they lost on these same types of claims. Let me address a couple of other issues going directly to that which the appellant's counsel raised. Actually, if I could just finish on the first one, I was talking about the practical reality of treating this case differently, of creating what we believe would be new law. And I started to say that you just couldn't make commercial loans. And the point that I was going to make is this: loans are made pursuant to an underwriting process. What is my liability if I make these funds, if I commit them in a certain way? And how could a lender ever use the law to gauge what its liability will be? How can I get, if not certainty, relative certainty, or at least enough understanding and comfort to make a loan given the status of the law? And here, it's a runaway. You would have employees of companies who get terminated, or the company goes out of business, they lose their job. It's unfortunate for sure, but you can't account for that. You can't account for people off-site, as here, as one or more of the plaintiffs is, who have alleged damage to their house, allegedly that goes derivatively all the way back, step after step. You could never make a loan under those situations. The only reasons why these loans could be made, in my view, would be because we have the law as it is, which defines what the duty and relationship is. I'll move on to the next point. Question was asked about whether or not the argument concerning 6.4.2 had been raised in the record. And I'd just like to state for the record that Judge Flatley cited to section 6.4.2 in his decision. And the appellants themselves cited to 6.4.2 in their respective reply briefs, both in the Neeson case at page 18 and, I'm sorry, the Nitty case, I misspoke, I apologize, at page 18, and the Leeson case at page 18, and that's both of their replies. And section 6.4.2 provides, among other things, that the borrower had to satisfy these conditions precedent, which we had just discussed. That is the process by which the repairs would have to be done. The borrower would have to do it. They would then come and get reimbursed as appropriate. Why am I raising that question or raising that point? Well, I'm raising it for two reasons. One, to establish that, yes, it was in the record. And two, to demonstrate that when we refer to 6.4.2, we're talking about the borrower's obligation. And the way that they've structured their claims appear to be based on a piggybacking of various different agreements to ultimately get themselves to be seen in the shoe as stepping into the shoes of the borrower. My point made more plainly and more simply is this. These attenuated plaintiffs, the appellants, can't get greater responsibilities, greater rights, I should say, greater rights and benefits than the borrower itself had. That would be extraordinary. And again, the borrower doesn't have the rights either. Doesn't have the rights either. And these attenuated appellees certainly can't get more. Appellants can't get more than the borrower had. Another point. Part of the thesis of the appellant's approach is that there was money to be had. If only the money would have been spent, this whole thing would have been avoided. You just should have made the repair. Well, again, and I'm not going to belabor it, frankly, I think I already have. The loan agreement says what it says, the obligations are what they are. But even beyond that, the ability to pay for something is different than the obligation to pay for something or to do something. And I think that's a material distinction here. I understand the desire to say, well, you had money, you just should have done it. But the world doesn't work that way. And it particularly doesn't work that way when you have a series of agreements that define the parties' rights and obligation. Ability does not equal duty. And you can't try to cobble together a duty based on the fact that someone had the ability to do something, particularly when that which it supposedly should be doing is exactly the opposite of what's set forth in the loan documents themselves. I also want to address an issue that came up with respect to what case law there is that says that an assignment is binding on a party, an assignment of duties is binding on a party where there's an express exclusion of such an assignment. And obviously here, we have that. There is an assignment of leases and rents, but in that ALR, as we refer to it, it specifically disclaims that. The answer is, I do not believe that they have cited a case for that proposition, which to me is endemic of another sort of thesis here, which is it's about a bad thing happening, a flood. People lost money. People had, different kinds of problems. But that's separate and apart from relying on the law that gets you there. And here, this is just another way of trying to create this duty when there is none, because, again, I don't think they've cited that case. Another thing that the appellants haven't seemed to directly attack, certainly didn't bring it home.
Mr. Cronus, your colleague did mention a case, and I confess I didn't hear the name clearly. Did you hear the name of the case?
I did not hear that either, Your Honor, but I'm interested.
What was the name of the case?
Lip versus Ginger.
You want to talk about that?
I do, Your Honor. So, Your Honor, the Lip case held that an equitable owner of property, in other words, an entity that had entered into a contract for the purchase of the property, entered into the contract, didn't actually own the property, may owe a duty of care to individuals injured on the property when that equitable owner has possession or control of the premises. And a few things. First, we're not talking about an assignment of leases and rents like we're talking about here. Second, this was a case under Missouri law, and we believe that it is not applicable to these proceedings. The Lip ALR, different from ours, was in the context, actually the court's treatment, I should say, the court's treatment of Lip was, or of the ALR, was in the context of a defendant that was under contract to own the premises. So the court analyzed the defendant's potential liability only after finding that the defendant was a, quote, equitable owner by virtue of the property sale contract. Here, and unlike in Lip, the appellees did not own the mall, were not under contract to own the mall, nor did they possess the mall. Therefore, Lip is completely the opposite.
You have a response to the subject matter jurisdiction issue that my colleague raised in the Needy case?
Well, I wouldn't respond. I want to look back into that, and I would say the jurisdiction can be addressed at any point in time, and that is something that we will look into.
Anything further?
I'm sorry?
Do you have anything further?
I do, Your Honor, if I may. I had mentioned just very briefly, and I just want to make the point firmly, which is with respect to Wells Fargo, there are precious few references to Wells Fargo specifically, and specifically with respect to a contractual relationship that they had. And what I would point out is in the briefs, what we believed we saw was, again, this sort of cobbling together of provisions, cherry picking here, cherry picking there. And we also saw together a fairly, I guess I'd call it casual use of, identifying the parties, casual way of identifying the parties. And it was, all of the defendants at the district court level, all of the appellees. But the fact of the matter is that they are different in the way that they are situated. Wells Fargo and the trust entered into different contracts. And I don't believe that they have we have set forth the specificity with respect to that in our briefs, and we're comfortable with what we have there. But I think that the lumping them together, Wells Fargo together, the two appellees together, is part and parcel of this really desperate way to try to cobble together some liability where there isn't. And I'll close with this. I understand that this was an unfortunate situation. Nobody hopes for this kind of thing. Nobody hopes for this kind of a flood. But the contracts are what they are. The law of negligence is what it is. And to create liability here, we believe would be very inconsistent with the existing law. Thank you very much.
All right. Thank you, Mr. Cronus. Mr. Skaggs?
Yes, Judge, if I may, and do I need to wait till the top? There we go. I guess I've got 7 minutes, 6:59. In response to what he had to say, in my mind, he said, well, find another case. Well, what that tells me is this is a very unusual situation. And you can afford relief in this unusual situation based on well-established principles of liability, tort/economic loss liability, and under the contract, and not throw over the multi-billion-dollar securitized loan business. The problem I think you've got is this is very sophisticated people that put this deal together. And if you look at the prospectus, it's very detailed. And they have many, many people involved in this transaction. They could have written this document any way they wanted to. And Mr. Abruzzino was in bankruptcy at the time. The $13 million plus went to pay off loans from his prior bankruptcy. So he didn't get, it wasn't a cash transaction to him. It was a evening out the liability. They chose to write it the way they did. And what you've got, I think, is you have to look at the entirety of the documents. They all come into play. It's one transaction, the case of management agreement, deed of trust, the loan agreement, and so on. They're laid out in the pleadings. Those all fit together. And one of the things they have in them are these multiple powers of attorney from Tara / Mr. Abruzzino to the other parties. They had every ability to do that which they should have done. And
but you just said, okay, so your friend on the other side's argument is banks have to be able to lend money without taking on liability. And I heard you just say they could have written the contract anyway. So how would Wells Fargo have written this contract to make clear that it cannot be held liable for something like this in your view?
Well, the first thing they do, they could have changed it from assumption of leases and rents.
But presumably they want the rents in order to secure the loan on this risky transaction.
Right, but in addition to rents, they assumed the leases. And of course, under the restatement of torts section, I can't remember 308, it's in the papers, an assignment includes unperformed duties if it's an absolute assignment. So they did not have to make what sounds like an absolute assignment. All they had to do was configure this particular transaction for this unique situation. Nobody told them to loan money on a shopping center in Elkview, West Virginia that had one way in and out of it. That is in the record. And the one way in and out of it was in the floodplain. And that was noted in the prospectus as a negative characteristic by the appraisers. So I mean, I don't know what to say about it. They chose to enter into this arrangement under West Virginia law, Akins versus DeBow, however you want to characterize West Virginia's characterization of liability. They chose to do that. And this was an awful situation. It happened about 6 p.m. People were stranded overnight. And I understand, I'm a lawyer. I tell clients all the time, yes, the fact that that car could have hit you doesn't mean it did. But they're very fortunate that there wasn't a fire. Somebody didn't have a heart attack and die. The gas lines were ruptured. This site had at least one, I can't remember if the Kroger Fuel Center was open then or not. They had underground storage tanks and gas stations, multi-story buildings. So, you know, they knew everything they needed to know about this situation. And you want standard of care, are they really telling me that every bank in the United States of America confronted with a situation where we need $24,000 to protect our $13 million investment would not fix it? And then evict or terminate the deal, foreclose, sue Mr. Abruzzino, exercise their other remedies? Who would allow this to get to this point? So my argument is, I don't know how else to say it, they broke it, they bought it. And when you look at all of those agreements, that way they fit together, yes, they're all over the lot. It was a one-size-fits-all transaction that attempted to maximize the bank's profit, interest, and ability to act, minimize their duty. And that's not the law, is it? You have a duty to use reasonable care under the circumstances. So that's the essence of my argument. I'm down to a minute 46. I don't know. Let's see. That was basically my response to ability versus obligation. We contend they did, in fact, have an obligation. It was they were confronted with it. So with that, unless the court has any further questions for me, I'll be happy to sit down.
All right. Thank you, Mr. Skaggs. I want to thank, on behalf of the panel, both counsel for their arguments. In normal times, we would exercise our tradition to come down from the bench and greet you personally. Obviously, we're not going to do that here today. My hope is at some point down the road, we'll be able to get back to that, but today is not the day. But please know that we're grateful to you for your arguments and appreciate your being here with us this morning. The case has been submitted, and we'll move on to our second case.
Thank you, Your Honor.
Yes, Judge. I actually had this COVID after my
All right, we'll hear argument in Roberts versus Gestamp, West Virginia, LLC.
Thank you, Your Honor. My name is Richard Walters. I'm here today with Ryan Walters for the law firm of Schaefer and Schaefer in Charleston, West Virginia. We are here today on behalf of the appellant, Casey Roberts, appealing the district court's order granting summary judgment to the defendant's appellees in this matter. The district court's decision had multiple errors in it, not only citing the wrong law, but most importantly, ignoring a plethora of disputed facts in this matter. The circuit court's decision properly cited the proper standard. And on page 2 of the decision stated, when determining whether summary judgment is appropriate, a court must view all the factual evidence and any reasonable inferences to be drawn therefrom in the light most favorable to the non-moving party. It's our position that the court turned that standard on its head and actually looked at the facts in favor of the moving party when making this decision. This court, as late as last year in Cedar versus Reston Town Center, 988 Fed 3rd 756, discussed the standard and stated that that a plaintiff need only provide, quote, evidence beyond speculation that provides a sufficient basis for a reasonable inference of causation. In the case of bar, it's our position that we met that standard by far. And in fact, what this case is really all about is the notice that Mr. Roberts provided to the appellees for his need for medical leave. And if you look at the standard of the facts in favor of the non-moving party, it's clear that Mr. Roberts did properly provide that notice. What we're looking at is really, did Mr. Roberts provide the notice of his need for medical leave as required by the Family and Medical Leave Act? And the answer to that question is emphatically yes. Not only did he provide the employer with the proper notice he needed to under the Family and Medical Leave Act, he also did so in compliance with their own policies.
Like, there's kind of a preliminary question, isn't there? Did he provide any notice that he was going to be absent at all for any reason as required by his employer's policy before you even get to the FMLA question?
Right. And the way we're looking at this, Your Honor, there's the notice he was required to provide is under the FMLA and under their policies. And under the FMLA and under their policies, this is an unforeseeable event. He did not know that he was going back into the hospital. He did not know he had a reoccurrence of the infection. So with an unforeseeable event, what you're required to do is provide notice as soon as possible. And Mr. Roberts did that, and he did it emphatically. He did it on the Friday before, telling them that he's going back to the hospital. He did it on the Monday that he was off work, telling them that he was in the hospital. So as far as that initial standard,
But I guess the employer's response is, but he didn't provide notice for the days that he was absent, right? So the 21st, et cetera, so all the days after that.
That was after he was already in the hospital, after he had already provided them notice that he was in the hospital. So
what did he say that gave them notice he was going to be out on the 21st?
On the 21st, actually it was on the 20th. On the 20th, he sent the message to his supervisor saying, hey, I'm back in the office. I'm sorry, I'm back in the hospital. The infection has returned. I don't know how long I'm going to be here. Under the employer's policies, and specifically under 29 CFR 303C of the Family Medical Leave Act, once the employee provides the employer with adequate knowledge that it may be a qualifying event, it's the employer's obligation to then reach out to the employee if they need any additional information. And both the HR manager and the supervisor for the defendants testified that the manner in which Mr. Roberts provided notice of his need for leave was adequate under their policies. He had done the exact same thing.
Is that under the CFR? Is that the employer has to reach out if they need any further information to determine whether it is covered leave? That's how I read it, but I'm not entirely sure.
Yes.
That if they need more information to determine, is this leave going to be covered by FMLA?
Correct. Under 303B, it states the employee must specifically reference either the reason for leave or that he's has been hospitalized overnight. The employer will then be expected to obtain additional information even through informal means. So once they've been notified that he's in the hospital, if they have any additional questions beyond that, then it's their obligation to reach out to the employee, even through informal means, to find any additional information they need to make that determination.
But it doesn't switch the burden under, an employer's usual policy that it's the employee's responsibility to call in and say, hey, I'm going to be out today, or hey, I couldn't call you yesterday, but I was out yesterday and today because I'm in the hospital with that thing we talked about earlier, right? It doesn't become the employer's obligation to call every day and say, where are you? Are you in the hospital? Are you on vacation? Have you taken a sick day?
Not once, no, Your Honor. And that's why when you look at what the usual and customary procedure was, we have our courts, well, a couple courts have discussed what that usual and customary procedure is, how those policies work. And in James, which is unfortunately not in the materials, the District Court of North Carolina in 2009, Lexus 61885, held that even when there are written policies, if the plaintiff can show that the usual and customary manner by which they have this communication with the employee is some manner other than the written policies, then summary judgment is not appropriate.
Yeah, and I'll let you move on to that. I guess I have kind of a preliminary hang up that I don't even know we get to usual and customary because there was no notice. It's not, well, is Facebook okay? Is calling okay? But I don't see any notice in the record that he's going to be out on these particular days.
Following his hospitalization after the 20th.
Right.
And that's when, and that's when that burden does shift, Your Honor. Under the FMLA, under those regs, once he notifies them like he did back in July 27th and says, hey, I'm in the hospital, they reached out to him. And then they had that communication. It's a two-way street. They had that communication.
Mr. Walters, can I ask you about that? So, but one of your arguments is that, let's assume for the moment that Judge Rushing's point is well taken. One of your arguments is that Mr. Roberts was in fact fired on the 21st. And so at that point, the notice becomes academic.
It does. And one of the disputed facts that we point to in our rebuttal brief is our reply brief is that.
Or at least there's a dispute about that. I mean,
there's a dispute about it. Absolutely. The employer takes the position that no, we didn't fire him until the 28th. We made the decision to fire him effective the 21st. And they point to a document that has a date on it. It's our position that when on the 21st, and this is the key, on the 21st, when HR, Mr. Slater, Robert's supervisor, contacted HR and says, Mr. Roberts hasn't checked in. He didn't tell HR that on Friday, he told me he was going to the hospital. He didn't tell HR on Monday, he told me that he still was in severe pain. He didn't tell HR that on Tuesday, he told me he's in the hospital for the infection again and doesn't know how long he's going to be out. None of that information was provided to HR. So when HR made that decision, they did it on the 21st. They didn't even give the 2-day required notice under the FMLA. And that decision was made at that point in time. So it doesn't matter if Mr. Roberts had checked in on the 23rd.
And what was your evidence? I know you dispute the date. And I think, but correct me if I'm wrong, it all comes from one document, right? You read that document and say, look, it says 21st. And then the employer reads the document and says it has another date on it. There's no conflicting testimony, is there?
Yes, Your Honor. It's just a document that can be, our argument is it clearly says on that document, his termination is the 21st. That represented unemployment. His termination was the 21st.
And a witness testified and explained why those two dates were on there.
They claim that because the date up on the 28th is when they put that in, and therefore we're supposed to infer from that decision was made on the 28th. It wasn't just entered on the 28th. And again, our position is that's not sufficient evidence on that. But even if you go to your...
What's the contradictory evidence?
Is just the document itself, Your Honor, okay. And the representations they made that his last date was the 21st, and they acknowledged that his termination was effective the 21st. So the question becomes, when did they make it effective? But it's clearly the 21st.
Have you preserved an argument? Because what I'm finding most difficult about this case is, if I think they couldn't have fired him on the 21st, or if I think there's a genuine dispute of material fact about whether they could have fired him on the 21st, but I don't think there's a genuine dispute of material fact they could have fired him on the 23rd, which is a point at which he's no longer, I mean, he says, I'm going into the hospital, don't know how long I'll be here. But then he's discharged from the hospital and is at home for a week and says nothing to his employer. I think they could have fired him on the 23rd. Have you preserved a claim that it was wrong to fire him on the 21st, but they could have fired him on the 23rd?
Absolutely, Your Honor.
Where?
And the reason being is under the argument that the 27th, June 27th, when the same situation happened, and August 20th are the exact same scenario. The HR director.
No, I guess I'll say, where have you preserved an argument that your fundamental argument is they couldn't fire him at all? But where can I see that you've made the alternative argument that there was a 2-day period when they couldn't have fired him?
It's not we didn't rely upon the two-day period, Your Honor. What we relied upon was 303B, where the FMLA says once the employee provides them an adequate notice, if the employee needs any additional information, they're required to reach out to the employee. It is a burden shifting. They are required to reach out even through informal.
Okay, but assume I think that's wrong. Assume I think they can fire him on the 23rd. Do you have a claim that they were wrong to fire him during the 21st to the 23rd, but he could have absolutely been lawfully fired on the 23rd?
Not if you take the position, not if Your Honor takes the position that the notice was inadequate. If the notice was inadequate and the employer was not required to reach out at that point in time, then no, there would be no preservation of that claim, because at that point in time, we would not prevail.
So what is your authority? I mean, I understand there's a question of who has to give notice to who, but I mean, just taking a step back and trying to think about how this scheme is supposed to work. I suppose maybe it makes sense for him to say, I'm going into the hospital, not sure how long I'm going to be here. And maybe it's reasonable to say the employee then doesn't have to provide daily updates because it's covered by his previous statement. I'm in the hospital until I tell you I'm not in the hospital. We'll let you know when I'm not. But in what world does it make sense to say that the employee can then be discharged from the hospital, stay home for an entire week, and not tell his employer at any time during that week? Walk me through how that makes sense as a matter of what this statute is designed to do.
The reason, Your Honor, is that's not what the decision was. The decision was we're not firing because we didn't hear from him since 28. The reason was we never heard from him. We've never heard from him. He didn't tell us he's in the hospital. He didn't give us any notice whatsoever.
But what if they had said that? What if they'd fired him on the 23rd and said, what are you talking about? Or what if the day he came in for the first time a week later and they said, where were you last week? And he said he was at home. And they're like, we thought you were in the hospital. You're fired. In your view, could they have done that?
No, I do not, Your Honor. And the
Why
reason
not?
being is because all they know, the only information the employer has is on August 20th, after being in the hospital for 2.5 months, he's back in the hospital. In the last 3 months, he's only worked 4 days because he's been in the hospital or been under medical care. So he comes back to work for 4 days, goes out on the 5th day. All they know is he's back in the hospiel.
Well, they assume he's back in the hospital, but it turns out he wasn't in the hospital.
Well, he told them he was in the hospital. He was
Right.
in the
It turns out
hospital
that
on the
was not
20th.
true.
So once he tells them that he's in the hospital on the 20th, on August 20th, he's back in the hospital for the infection, then yes, the burden does shift to the employer to say what's going on here. And it's not an onerous burden under the circumstances. And you can't look at this in a vacuum. You got to see what's going.
Why does the burden shift? I mean, he said it's about the appendicitis. We should assume like that was already covered by FMLA. The employer knows that's a covered leave. So there's not even really, doesn't seem like a dispute about whether if they knew he was in the hospital for an appendicitis, a continuation of that infection, that this would be covered. The question is, does saying, don't know how long I'll be here, does that mean an hour, 2 hours, 3 hours a day, 4 days, a month?
Yes.
And does the employer then have to call him until they figure that out? Or do they, once they determine this is FMLA leave, they know it's covered, but it's still his job to tell them when he's going to be absent?
Now, that's what 303, 29 CFR 825, 303B talks about, is once he hits that threshold, once he gives them enough information to notify them that the reason he's not at work is an FMLA qualifying reason, that burden does shift to the employer to say, well, what's going on? How long are you going to be out?
But what burden? The burden shifts for them to determine that whether or not it's FMLA leave, because we don't expect employees to know what FMLA leave is, to know their rights. So the burden shifts to the employer to determine whether it's covered leave. But here, there doesn't seem to be a problem with that. They know from the moment he says it's an appendicitis infection that this relates back to the previously covered leave. So it's not as though then all the employment policies that he's signed on to, the burden shifts under them. And yes, it becomes the employer's duty to call and determine whether he's going to be out that day.
If you go beyond simply identifying as FMLA leave, it's the employer's policies about providing notification within 15 days. He has 15 days from the time that he notifies them of the need for the FMLA to provide the medical certification. If they need that, all they got to say is, look, you got 15 days to get us something from your doctor. We need to know when you're going to come back as soon as you know. There's got to be something. They want to claim that Mr. Roberts went silent and didn't tell them anything. The employer went silent and didn't communicate anything. This has been a process that's been going on for 3 months. And suddenly the employer wants to ignore all that. And when you look at the totality of the circumstances, it's not appropriate in this circumstance for the employer to say, okay, we know he's on FMLA, but if we don't hear from him, let's go ahead and fire him. At that point in time, they do have that obligation to say, okay, let us know when you're going to be able to come back. Here's your certification. You need to fill out the certification. They've got to tell him something. They've got to say, okay, you've got to get that certification back to us within the 15 days. None of that occurred. And in fact, not only didn't it occur, the supervisor lied about the reason why he wasn't there and testified that he didn't even know. So it does go back to that notice requirement. And once that notice requirement is hit, then yes, the burden does shift to the employer. If you're going to fire him, you better reach out and say, what's going on first? Because you know he's off for an FMLA reason.
So you read the notice requirement as not limited to the simple question of whether or not he's entitled to FMLA leave, but how long he's going to be on that leave.
Any questions the employer has related to that leave once it is qualified as FMLA, once they know that, once they have enough information to determine as FMLA, any additional information has to be a two-way street. He told them, I'm out indefinitely. They want to know more information. They have the right to gather as much information as they want, but they've got to ask. They can't just pretend like, well, he's out. We know he's out. We're not going to worry about it. Should Mr. Roberts contacted them before the 3rd? Absolutely, he should have. Was he required legally to do so with no contact from the employer? No, he wasn't. The employer had to reach out. He's got 15 days to provide certification from his doctor. They didn't even ask for it. They just fired him. And it all goes back to their argument, which is not supported by the factual scenario here, that they didn't know about the notice, because they absolutely did know about the notice. And that's the issue of fact that was misinterpreted below.
All right, Mr. Walters, you've got some time left for rebuttal. Thank you very much.
Thank you, Your Honor.
Mr. Ramey? Is it Rami or Ramey, sir?
It's Ramey. May it please the court, Travis Ramey for Gaston. Your Honor, the FMLA seeks to balance the interests of employers and employees, and to help achieve that balance, it imposes some requirements on employees. They have to follow the employer's usual and customary notice procedures when requesting leave. They have to provide sufficient information to the employer to make a determination whether leave is FMLA qualifying. And they have to cooperate with employer efforts to obtain additional information. Here, Mr. Roberts failed to satisfy those obligations, so he was not entitled to FMLA leave. To begin, Roberts undisputedly did not comply with Gestamp's written procedures for requesting leave. Those procedures required him to call a call-in line at least 30 minutes before his shift began.
But you agree, the regulation does not say you have to follow your employer's written policy. It says you have to follow your employer's usual and customary policy, right?
Absolutely. I agree that that's what the regulations say, Your Honor. And so really the question here is, what is the written policy the usual and customary notice procedure?
And would you agree that when the district court said that is a question of law, that was clearly wrong? How could that possibly be a question of law what the usual and customary policy is?
Well, Your Honor, if the facts underlying are undisputed, then it would be a question of law. And here, the only evidence in the record of any modification of the written procedure into some sort of alternative usual and customary procedure is 2 instances where there were Facebook messages exchanged about leave, only one of which gave any notice about absence. And that sending of a Facebook message to Gary Slater by Roberts wasn't really a variation from Gestamp's written policy, because under Gestamp's written policy, a person normally must provide personal notice through the hotline. However, the policy states that in an emergency, the employee can have a third party provide that notice. In other words, Mr. Roberts could let Slater know that he was going to be out, and Slater could then not notify Gestamp that he would be out, and that's consistent with policy.
Mr. Ramey, can I ask you about the Facebook messages? Because you seem to indicate that there was a very limited exchange between Mr. Roberts and his supervisor, but that's not accurate, right? I mean, there was a pretty fairly consistent exchange over Facebook between Roberts and Mr. Slater. So why isn't that, I mean, that's sufficient deviation from the typical practice that would make it at least a factual question as to whether or not it was usual and customary?
Well, I think there are 2 answers to that question, Judge Diaz, and that's first, what's relevant here are communications that provide notice of absence, not just communications in general. So really the only 2 that are arguably communications about notice of absence, other than the ones that are directly relevant to this case, the mid-August to September period in which Mr. Roberts was out, are a June 14th communication that began from, actually was initiated by Gary Slater, in which he said, "What's the word?" And then Mr. Roberts replied that he had an infection, it was staph, and they had him out because he was on antibiotics. That communication unambiguously shows that there had been some previous communication about a health issue. The only other one is the emergency communication on the morning of the 27th, in which Mr. Roberts informed him that he was apparently on a gurney on the way back to surgery.
Well, I know you want to skip over that first one, but that first one strikes me as really bad for you, because it's an instance in which this gentleman's supervisor is himself choosing to initiate a conversation about his health status over Facebook Messenger. And then your client wants to turn around and argue that it's inappropriate for him to notify his supervisor using the previous method that his own supervisor had used to initiate. Why isn't that really, really bad?
Well, because, Your Honor, I think what's relevant here is communications from Roberts to Gestamp, notifying Gestamp that he will not be at work.
I mean, you could slice it that way, and maybe a fact finder would find it that way. I mean, but another way to think about it is employees take their cues from supervisors, and when supervisors convey through their conduct that we're going to talk about your health situation via Facebook Messenger, maybe a reasonable employee concludes this is how my employer or my supervisor wants to talk about health information.
Your Honor, assuming that's true, we still have the problem of, let's assume we do have a modification of the policy, the written policy, to some other usual and customary policy. Well, then we have to know what the policy is. And if we're using the appendectomy leave as our sort of acme example of that, then what did Mr. Roberts do there? He didn't just send a Facebook message on the 26th that said, I'm going into the hospital to have surgery. I'll be back at work at some indefinite time in the future. What we see is he comes out of surgery, and the day of his surgery, he informs Slater, I can't do anything for 2 weeks. They've given me a doctor's note. And the very next day, he brings the doctor's note to Gestamp. Mr. Roberts in his briefing paints this as the notice was purely this Facebook message, but the previous example in the appendectomy shows that the notification and the information he supplied to Gestamp was a lot more than just a one-off Facebook message saying, I won't be at work. It was a pattern of him on his own initiative, providing additional information about how long he would be out. And that's consistent with the general rule that employers are entitled to notification of the anticipated duration of any FMLA leave. That's necessarily a part of their decision to determine whether leave is FMLA qualifying.
But with that, the fact that he sort of engaged in that exchange the first time around, does that necessarily require him to do it the second time around when in the face of a regulation that appears to impose an obligation on the employer once notified of the hospitalization to inquire further?
Well, Your Honor, what I think it shows is that if the written policy is not the actual policy, if there's some unwritten policy of how to provide appropriate notice and what that notice must contain, that Mr. Roberts understood that it required more of him than to just send a one-off Facebook message saying I'll be out of work for some unknown and indefinite period of time. So if we're using his prior conduct and Gestamp's prior conduct to show a modification of the policy, I think it's directly relevant to look at what he did before and to see the vast disparity in the amount of information he provided to Gestamp when he was out for his appendectomy and the dearth of information he provided in mid-August. Additionally, this duty to follow up and inquire is not the only duty that's at play here. If you look at sections like A25303A, it implies an employee's duty to follow up with additional information. When an emergency abates, you have 302B's obligation to, when you have leave where the timing and duration of it is unknown, once the employee knows the timing and duration of that leave, he has an obligation to inform the employer. And Mr. Roberts had that information when he was discharged from the hospital on August 23rd. What we see is that the duty to inquire that Gestamp may have under the regulations is not the only duty.
Before you jump to the 23rd, can you talk about the question about whether there is in fact a genuine issue of disputed fact as to when he was terminated?
Your Honor, I don't believe there is an issue of fact. The documentation, it's on J565, shows it unambiguously lists his termination date as August 28th, 2019. It actually states that twice on the document, if I'm correct. There is a notation for August 21st that states job terminated or terminated for job abandonment. And in his deposition, Scott Hughes explained why that note was there on the 21st. He said that they had made his termination retroactive to the 21st because the 20th was the last day for which they knew where Mr. Roberts was. He was on vacation that day. That the termination was made retroactive purely for their payroll purposes, and that's why the notation is there on the 21st. But he repeatedly stated unambiguously, I made the decision to terminate him on August 28th.
So what do I do if I think that was illegal then. So you said they did it for payroll purposes, which is another way to say they didn't pay him. What, again, this is the question I asked your friend on the other side. What if I think they could have terminated him on the 23rd, but that I think there's at least a genuine issue of material fact about whether you could have terminated him before that?
Well, Your Honor, I think that the issue is they did not terminate him until the 28th. So I don't think there is.
Well, I mean, I agree. I guess you're saying they didn't actually do it, but if they did it retroactive to that date, I mean, doing something retroactive to a date is kind of doing it to that date, right? That's the reason you do something, make something retroactive.
Your Honor, I guess, and I'll concede, Your Honor, that I hadn't thought of this, and so I don't have a well-reasoned, well-thought-out response to your question. But I guess if the court concludes that it was illegal to terminate him on the 21st, and there is an issue of fact as to whether he was terminated on the 21st, but they could have terminated him on the 23rd, and then perhaps he has an FMLA interference claim for 2 days. He was on unpaid leave, so I don't really know what his damages would have been.
Can I ask you a question about that? This question seems to presume that the employer's policy is that if you're a no-call, no-show for 3 days, then the employer can terminate you, but you get paid for 3 days of not showing up. You get paid for 2 or 3 days of no-call, no-show. Is that the employer's policy?
No, Your Honor. He would have to have taken paid leave for that time. And that's
those no-call, no-shows, those are, if you're terminated for that, that's retroactive. You don't get paid for those days that you didn't show up. That's
correct, Your Honor, because you wouldn't be taking ETO or vacation time for those days. These are hourly employees. If they don't show up and work, he doesn't get paid. So that's why I say, in response to your question, that perhaps there is academically there may be a claim for those 2 days, but I have no clue what Mr. Roberts' damages might be for those 2 days. Really, this case, in my opinion, is fairly analogous to the Seventh Circuit's decision in the Lewis versus Holzman Fort Wayne case, which is cited in the briefs. In that case, you had an employee who had an asthma attack and was out on FMLA leave for 4 days and then took a 7-day vacation and never informed the employer when she would return to work. So after the 7-day vacation ended 3 consecutive days, she no called, no showed to work. And the employer, therefore, terminated her employment. She returned with medical information that she was under doctor's care for those days. And the Seventh Circuit said that termination did not violate the FMLA because she had had an obligation not to keep her employer in the dark and to inform the employer of when her expected return was. That the FMLA may provide protections, but it doesn't extend to silence from the employee in the face of information that the employer needs to determine the duration and qualification for FMLA leave. That seems to be directly analogous to the situation here. Now, I understand Seventh Circuit decisions aren't controlling here, obviously, but it is analogous reason. But even if we get past all of that and we do get to Gestamp's duty to inquire, to make inquiries for additional information, let's assume for the sake of argument that the written policy that Mr. Roberts definitely violated is not the usual and customary policy. Let's assume that the usual and customary policy requires only the initial Facebook message saying, I'm in the hospital, my pain is back, they think the infection is returned, I don't know when I'll come back. Let's assume that that's sufficient and complies with the usual and customary policy. Gestamp did attempt to engage with Mr. Roberts in at least 2 ways. The first is the calls that Heather Dornsife made on August 22nd and August 23rd. Now, I understand that Mr. Roberts' position is that for the purposes of summary judgment, those calls didn't happen. But to do that, I think he overreads some testimony from Scott Hughes in his deposition about whether there would be a notation of those calls in Gestamp's AOD attendance system. He reads Mr. Hughes' deposition testimony to say, if those calls had been made, there would be a note. That's not what Mr. Hughes said. What he said was, in response to a question of whether there would be documentation of the calls, he said there may be a note in the AOD system. He was asked if that was typical, and he said it's very possible to do that. Is that something they're supposed to do? And he said, yes, they do that. I don't see that as saying that if the calls were made, there would be a notation. And so I don't think that a reasonable fact finder could conclude from that in the face of all the unequivocal testimony that the calls were instructed to be made, were made, and that Dornsife responded back to Scott Hughes that the calls were made and they could not reach Mr. Roberts. I don't think there's an issue of fact as to whether those calls were made.
Is there some dispute about where the calls were made? They were made to his home number, not his cell phone?
That's correct, Your Honor. They were made to his home number, which did not have voicemail, but that number was the number that Mr. Roberts provided to Gaston for contacting him. That's
I guess
the
we
number
go back to
they
the
had.
usual and customary way of communication. If you're conceding that there's a deviation from that, why wasn't Facebook the manner in which to follow up with him?
But Hughes' testimony was that that's not how HR operated. They called the number that was provided to him. So at least insofar as it's contacts from human resources, that was their usual and customary method of contacting employees, was to call them
If
at
they knew, well, I guess there's a question about whether or not HR actually knew where he was. There's some dispute about whether Slater actually told HR back then. But if they did know, then what sense would it have made to call him at home if he was still in the hospital?
Well, Your Honor, there's a couple of answers to that question. One, I don't think it is disputed that HR was entirely ignorant of the current situation regarding Mr. Roberts having been hospitalized. Slater's testimony was that he couldn't recall whether he told HR or not. And Scott Hughes' unequivocal testimony was, we had no clue. I didn't find out about any Facebook messages at all until during the litigation. So I think the undisputed record is that Human Resources did not know at all that Mr. Roberts wouldn't be at home. So I don't think that creates an issue there. But, and again, they contacted him at the place where he had, at the number they'd been told to use to contact him. And there was no voicemail. There was no ability to leave a message, and he didn't respond. So that's the first time at which we have Gestalt Human Resources reach out to inquire as to where he is and what's going on. If he had replied to those calls when he returned home on the 23rd, of course, they now know where he is and they know what's going on. If he had brought by the notes on the 23rd when he got out of the hospital the same way he had done when he was out with his appendectomy, of course, now Gestalt Human Resources knows where they are and they can inquire and get additional information from him. But as an absolute backstop, we have one undisputed instance in which Gestalt attempted to engage with Mr. Roberts to obtain additional information, and he refused to cooperate. And that's when he returned to work on September 3rd. When he returned to work on September 3rd, he could not clock in, so he reported to Gestalt Human Resources. Stevie Shamblin in the Human Resources office informed Mr. Roberts that he was not in the system and had been terminated. He then provided his medical excuse. And at that point, Ms. Shamblin didn't say, sorry, Mr. Roberts, tough, you've been fired, go home. Her response was, okay, let's get your supervisor in here. Let's get this worked out. Let's get it figured out. Let's sort this out. Now, at that point, under, I believe it's, let's see, the regulations would have allowed Gestalt to retroactively determine that it's H25301D. Gestalt could have retroactively decided that Mr. Roberts' time away had been FMLA qualifying leave. The regs allow for that, assuming that there's no prejudice to Mr. Roberts. But what is Mr. Roberts' response? And I don't see how that could have possibly been prejudicial to Mr. Roberts. It might have saved his job. But Mr. Roberts' response was not to engage with Gestalt and to deal with the inquiry. His response was to twice refuse to meet with the supervisor and tell Stevie Shamblin, no, thank you. I will just go clean out my locker and leave. At which point Gestalt concluded that Mr. Roberts didn't want to be reinstated. He didn't want to come back to work. And so they just let him go. Well, because Mr. Roberts refused to cooperate with that inquiry, at which Gestalt could have retroactively designated his time away as FMLA leave, he violated his obligation to cooperate with an inquiry by Gestalt to determine whether he was FMLA eligible. And that is enough alone to disqualify him from FMLA leave under the regulations.
Even after he'd been terminated? Do you
Yes, yes, Your Honor.
do you have a case that stands for that proposition, that the employee has an ongoing obligation to engage even after he's been terminated?
No, Your Honor, but it makes sense in the general scheme of things, given that the employer can retroactively designate leave as FMLA leave. One of the only couple sensible reasons for an employer to do that would be to fix a mistake in which leave had not been designated as FMLA leave, but it later turned out the employer discovered that it was FMLA qualified. It makes sense at that point to require the employee, in the sort of spirit of balancing interests and cooperation that the FMLA embodies in this relation between employers and employees, to require him to sit down and have a 5 or 10 minute meeting in which he explains the situation and they see if they can sort it out. Now, we don't know what would have happened in that meeting. We can never know. And we can never know because Mr. Roberts refused to engage with Gestamp and respond to their inquiry of trying to sort out what was going on. Your Honor, as I see my time has expired, unless there are further questions, I urge the court to affirm.
Thank you, Mr. Ramey. Mr. Walters, you have some time for rebuttal.
Thank you, Your Honor. The first thing I'd like to address is, if we can, go back to Judge Rushing's question about that interactive process and what obligation does the employer have once they learn that the employee is off an FMLA leave. This court has already addressed that issue in Peoples versus Coastal Office. It's in the pleadings in this matter. And in that case, the court found that once they are notified, the FMLA designation, the requirement of FMLA is to balance the demands of workplace and needs of the family, and encourages the employees and employers to communicate with each other in an interactive process that helps each party fulfill the needs. And in Peoples, the employer actually went above and beyond and was kept in the dark. The employee was very evasive and didn't provide the necessary information. And therefore, this court held that, the employer did what they're required to. They tried to find out what's going on, and they met with a stone wall, in fact, with lies about why the employee was off, and thus it wasn't qualified. But the point being is, the court held, and the argument was, you have to have that interactive process. You can't just pretend that you don't know your employee's in the hospital, especially coming off of 2.5 months in the hospital. You can't just pretend that happened and move on and hope that you have an opportunity to terminate them 6 days down the road. And I'm not sure, I apologize, I don't remember if it was Judge Rushing or one of the other honors that asked a question about whether or not there's any evidence out there that supports our position that termination happened on the 21st, other than that one screenshot that shows 21st and 28th. And I apologize, I forgot. Yes, there is. Emphatically, there is. Joint Appendix number 37 is the Gestamp's checklist. And on their checklist, the termination date is 8/21/19. So the very first document, one of the very first documents we received in discovering this matter, showed his termination list date as 8/21. It wasn't until we got further into discovery that they came up with a screenshot to say, oh, this explains that away. But their initial list, what their representations from day one were, is he was terminated on August 21st. The other issue I'd like to address is, and when you talk about whether or not there's usual and customary circumstances, or if there's reasons why which you can avoid or go around the written policy, you need look no further than Gestamp's declarations that they submitted to the court in response, in support of their summary judgment. At JA 724, the appellants submitted a declaration on behalf of Mr. Slater himself. Mr. Slater says in his declaration, June 27th, 2018, Mr. Roberts sent a Facebook Messenger message to me more than 30 minutes before their shift stating, hey, I won't make it into work today. I'm at the hospital. They're sending me for surgery. Because Mr. Roberts was hospitalized and in an emergency situation on June 27th, I did not consider him to have violated the attendance policy requiring him to call in to the hotline to report any absences. Scott Hughes, HR manager, testified likewise in his deposition and clearly stated that in an emergency situation, which is the second way in which you can provide notice, that not calling the hotline was permissible and using Facebook Messenger was permissible. Your Honor, you pointed out that the statement by the appellants that they had one or two conversations is a gross misunderstatement of the facts in this case. Over the 2.5 months period leading up to Mr. Roberts' termination. There were over 50 Facebook messages between Mr. Robert and Mr. Slater regarding his medical condition and where he was at. And again, to look at this as totality of circumstances, 2.5 months, 3 months, he works 4 days as a result of hospitalization. To pretend like they don't know what's going on is absolutely a disputed issue of fact. And when they claim that they did their interactive process because they reached out to him 2 times, Scott Hughes didn't say, you may find it recorded. He said that's what they do. When they call, they make that note. It's in there when they make that call. There was no evidence that they made the calls, not to mention the fact they were calling a house that nobody was at because he's in the hospital. And on top of all that, they're supposed to use formal and informal means. He had communicated, Mr. Slater had communicated with Mr. Roberts over 50 times in the last 2.5 months. There's nothing preventing him from picking up a phone and sending another Facebook message, or picking up the phone and looking at the ones he's already received. For the appellates to argue that they engage in the interactive process or suggest that is absolutely just not supported by the facts. And the final point, Your Honor, there is no case law out there that suggests once you're terminated from your employment, you're required to go grovel at your employer and beg for your job back. He was terminated. He said, I'll clear out my office. And he declined an opportunity to talk to the supervisor who knew he was in the office. And my time is also up. So if there are no further questions.
Thank you. Thank you, Mr. Walters. The case has been submitted. We appreciate counsel's argument. In pre-COVID times, we would come down and greet you personally. Obviously, we can't do that here today. We hope to be able to do that at some point down in the future. But know that we very much appreciate your arguments and your being here today. So with that, the court stands adjourned until tomorrow morning.
Thank you very much.
So the court stands adjourned until this afternoon.